So last time we left off talking about intentional torts. Specifically, we were talking about assault and battery. And so one of the things to remember about intentional torts is that the defendant intended to commit the act and they intended to cause harm, which is as opposed to reckless misconduct, which is typically they intended to commit the act, didn't intend to cause harm, and then as opposed to ordinary negligence, where someone typically didn't intend to commit the act and also didn't intend to cause harm. So we left off again talking about assault and battery, and so remember that an assault is a threat and the intent on the part of the defendant is to cause apprehension in the plaintiff. So if you threaten somebody, you're probably doing it to scare them or to get them to stop doing something that it is that they're doing, right? And so your intent is to cause them apprehension, to intimidate them. That's as opposed to battery, which is actual harmful or offensive contact. So in a civil sense, those two tend to go together. You usually don't put hands on somebody, if you will, without threatening them first, but sometimes they can be completely separate. But with both of those, with assault and battery, you probably intended to commit the act if you're the defendant, and you probably intended to cause harm. You intended to cause apprehension, or you intended to visit harmful or offensive contact upon them if you battered the plaintiff. So continuing then with intentional torts, we get to defamation. And so defamation law, the idea behind it is that your reputation is of value to you. So for example, if you are a graduating senior leaving Whitewater and you ask me to be one of your references, and if my impression of you as your reference or as one of your references is that I think that you're a really hard worker, you show up to class on time every single day, you have good writing skills, you work really well with your colleagues, you're intelligent, you're adaptable, all those kind of things. Let's assume I think all of those really wonderful things about you. Then that's worth some value to you, because if somebody, a potential employer, calls me and asks me what I think about you, I'm going to tell them all of those positive things, and hopefully by me selling you, by me telling your potential employer all those positive things, they'll be more likely to hire you. And so then it can be worth money to you, your reputation, what I think about you, because hopefully that'll help you get a job. And similarly, what your colleagues think about you, what your boss thinks about you, will be important to you because they'll help you get promoted with the company. They'll help you get raises, all of those kinds of things. And so you can actually, to some extent, you earn some money on the basis of your reputation, right? So because of that, your reputation is of value to you. So if somebody intentionally damages your reputation by telling a lie, then that can cost you money. That can prevent you from getting a job. That can prevent you from getting a raise or getting a promotion, those kinds of things. And so the idea behind defamation law is to protect your reputation from lies or falsehoods told about you that might damage it. So if you are the plaintiff and somebody has defamed you, somebody has told a lie that damaged your reputation, the four things you're going to have to prove. So the first one on there as the plaintiff is you're going to have to prove that the defendant made a false statement about you. So you're going to have to prove that whatever the defendant said is a lie. So for example, let's go the opposite direction with me recommending you for a job. Let's say you are all of those things. You show up on time, you're a hard worker, all of that. But for whatever reason, I don't like you. And so when an employer or prospective employer calls me and asks what I think about you, rather than telling them the truth because I don't like you, I instead say, well, they never showed up to class, and when they did, they really typically did pretty terrible work, and they slept through class, and they didn't work well with colleagues. They seemed to argue and fight a lot, and so I wouldn't hire them. So assuming those things are untrue, then what I've done is I have lied about you. I've slandered you, because slander is spoken. So I have verbally lied about you with the intent of damaging your reputation and thereby keeping you from getting that job. So the first thing you're going to have to prove as a plaintiff is that there was a lie. So one of the things that would happen in that case is maybe we would look at, or maybe the court would look at, attendance records. And so I said, you never showed up to class. But in fact, the attendance records show that you were there all the time. That's a pretty easily provable lie. So again, plaintiff has to prove first that there was a lie. And again, as you've probably guessed here, the primary defense on the part of the defendant is going to be to say that in fact, what they said was truth. So that's going to be how they're generally going to try to prevent that lawsuit or try to protect themselves against that lawsuit, is to say whatever it is that they said was in fact true. So then the second thing the plaintiff is going to have to prove is that there was publication of that lie. So defamation is, as you'll see in the next couple slides, is broken into two categories. So there's slander, which is spoken defamation. So slander is spoken, if that helps you remember. And so what publication means in the sense of slander is that the lie is heard and understood by a third party. So if I tell you a lie about you, I say, well, you never showed up to class. No one else, if it's just you and me in the room, nobody else heard that, and so that can't have possibly damaged your reputation because no one else was there to hear it. So as far as slander goes, then publication is that it has to be spoken, heard, and understood by third party, or by a third party or multiple third parties. As opposed to libel, libel is written slander, and so publication of libel would be things like in the newspaper, in a magazine article, on a blog, on social media. Those kinds of things would fall under libel. So something that is written, and also things like video. Even though it is spoken on a video, because it's fixed in a tangible medium, the form of the recording, that actually falls under libel, and that's an aside. So the second thing the plaintiff has to prove is that there's publication of that lie, that other people were able to read it or hear it and understand it, and thus have the opportunity for that lie to have damaged your reputation. The third thing on there that the plaintiff is going to have to prove is fault. And so with fault, what that is essentially that the defendant either knew they were telling a lie or they didn't care that it was whether or not it was a lie. So they may or may not be sure that what they're saying is a lie. So think of like rumor mongering. May be true, maybe not, but they don't care whether it's true or not. They're going to go ahead and convey that possible lie because they don't care. And so that would fall under fault as well. So really that would be negligence on the part of the defendant in that case. So fault is they told the lie intentionally or they didn't care if it was a lie. And then the third one on there is damage or injury to the reputation of the plaintiff. So for that, one of the big things you're going to have to prove with slander is that it actually did harm your reputation, which can be difficult if you're a plaintiff, and it should be, because sometimes people say bad things about you. Sometimes people lie about you, and it's unfortunate, but it shouldn't always result in a court case. And so it becomes difficult to prove, if you're the plaintiff, that whatever it is that the defendant said or wrote actually damaged your reputation. So let me give you an example that I use in class sometimes, which comes from a court case from the late 1990s from the Badger women's basketball team. There was one of the players on the team was allegedly having an affair with one of the assistant coaches, who I believe was married. And so the head coach called a team meeting, and in that team meeting, she looked at that particular player and said directly to her, "You're a disgrace." And that was all she said. So she didn't say anything about you had a relationship with the other coach or these are the things that happened, any of that stuff. She just looked at her and said, "You're a disgrace." And so that player ended up filing a lawsuit against the head coach, and it was a fairly large lawsuit. There were some contract things in there as well, but one aspect of the lawsuit was slander, was defamation. So again, spoken defamation, because the coach called her a disgrace in front of all of her teammates. And so the player was arguing that had damaged her reputation with everyone in the room who would have heard it. But one of the things to consider here too is falling under defenses, and we'll get to those on a later slide, but there's the other primary defense is going to be this concept of privilege. And so the main avenue of arguing privilege is that what you said, if you're the defendant, is opinion, right? So if, or because the coach said, "You're a disgrace," she didn't lie about that player. She just told everyone what her opinion of that player was. And so that type of speech, opinions, pure opinions, are protected speech. So you're allowed to express your opinion, but you're not allowed to lie. And so because that was pure opinion and it wasn't a lie about the plaintiff in that case, that aspect of the lawsuit was dismissed. So the plaintiff was unable to prove damage to her reputation there. So again, where that would be more easily done is as a plaintiff, you would have to show, and again, it would be tough to do, but you would have to show that you lost a job opportunity, or you lost a sponsor, or something like that. There has to be some sort of tangible way to prove that damage to your reputation. So don't think about suing everyone that says bad things about you. It's going to be difficult for you to prove, certainly the fourth point, or the fourth element that you'll need to prove. All right, so let me give you another actual case. You may be familiar with the sprinter there in the right picture. His name is Ben Johnson, the guy that's holding up the number 1. So that's Ben Johnson at the 1988 Olympic Games in Seoul, South Korea, and that's him just shortly after he crossed the finish line in the 100-meter dash where he won the gold medal. He's a Canadian sprinter. You can see Carl Lewis is right behind him in second place there. So hopefully you don't know anything about Ben Johnson, because this story is a little more entertaining if you don't. So Ben Johnson at the 1987 World Track and Field Championships, which I believe were in Rome, so he sets the world record in the 100-meter dash at those championships. He runs 9.86. And shortly after he does that, and he also wins the gold medal, as you'd expect, and shortly after he does that, his coach, whose name is Charlie Francis, goes to the assembled media that are there, as well as some of the track officials who are there, and tells all of them that Ben Johnson has gonorrhea. And Charlie Francis, when he told the media that, when he told the track officials that, knew what he was saying was a lie. So my question for you is, could Ben Johnson have sued Charlie Francis, his coach, for defamation? Well, let's run through the elements quickly. So the first one there, that there was a false statement concerning the plaintiff. It would be pretty easy for Ben Johnson to prove that he did not, in fact, have gonorrhea, and so he could prove that was a lie pretty easily. Was it published? Yeah, absolutely. So again, Charlie Francis told assembled media this, as well as track officials, and so what he said was also published in newspapers, magazines, etc. Became part of the evening news, all of those sorts of things, right? So it was definitely published and circulated worldwide. So check on number 2 as well. And then number 3. So did Charlie Francis intentionally tell a lie, or did he not care if he was? In this case, he knew it was false. He knew he was telling a lie, and he chose to do it. So, yep, fault. And then damage or injury to the reputation of the plaintiff. So if your own coach tells everyone that you have a sexually transmitted infection, could that cause damage to your reputation? Probably. If most of the information going out about you for at least a few days is that you have this sexually transmitted infection, that might hurt the likelihood that you're going to get sponsors. So you got to think about this in the context of, he just set the world record, and then his coach said that. So if Nike or I don't know, any other shoe company or whoever else, supplement companies, might be interested in sponsoring a sprinter, they might hold off for a little while because of that. So they might not want to just jump right into that sponsorship deal. So potentially that could cost him some money, right? And so he would probably be able to prove that there was some damage to his reputation. Now here comes the fun part. And this is where your prior knowledge would come in. So the question I have, because that just seems like absolutely outrageous behavior. So why in the world would his coach tell the media that Ben Johnson had gonorrhea? And the answer to that question becomes obvious pretty quickly if you know anything about Ben Johnson. So shortly after winning the 100 meter in the 88 games, Ben Johnson tested positive for anabolic steroids. I think specifically stanozolol. Doesn't matter which one. Anyway, pretty sure it was that one though. Might have been Winstrol. Anyway, test positive for anabolic steroids, and so he is stripped of his gold medal for the 1988 games. And so one of the things that happened, though, in the 87 games, of course, after setting a world record, Ben Johnson was drug tested. And so in his sample, there was a drug called probenecid that popped up. And so probenecid is a drug that is used to treat gonorrhea. And so what Charlie Francis was doing is he knew that Ben Johnson was going to pop up, or was going to test positive for using this drug. And so specifically, what probenecid does, it's a masking agent. So if you take that, it's going to cover up those anabolic steroids. So those won't show up as a positive test. And so, as you would expect, you're also not allowed to take masking agents. So what Charlie Francis was doing then was he was laying the groundwork that when that masking agent popped up, when probenecid showed up in Ben Johnson's test, that they would be able to argue, yes, he was taking an illegal drug masking agent, but he was taking it because that drug is used to treat gonorrhea, and so he had a legitimate medical reason for taking it, and so he shouldn't fail his drug test. So that's why they told the media that was to cover up the use of a masking drug, which is used in the treatment of gonorrhea. So ultimately, Ben Johnson also gets his 1987 World Track and Field Championship, or 100-meter dash championship, stripped as well. So one of the really prominent stories about anabolic steroids in sports, that's a pretty iconic picture of Ben Johnson winning there before I think the SI cover, the Sports Illustrated cover shortly thereafter says something like disgrace or something to that effect. So there we go. So moving on to the specifics. Well, we've already touched on them, so there's going to be a lot of repeat on the next couple slides. So again, defamation, you can break it into two categories. So there's libel, which is written, and then there's slander, which is spoken. And so you can see the definition of libel there. So it's the publication of a defamatory statement in writing. So the defendant, one of the ways they can defend themselves, as mentioned earlier, is that they can prove truth. So if the statement is false, though, an important thing to know, so if there is a lie, one of the things that the plaintiff has to do is to prove that the lie was published with malice. So the thing that was said about you that was untrue, it wasn't just accidental, but it was that the publisher of that statement intended to cause damage to one's reputation. So that's an important thing that the plaintiff is going to have to prove. So they're going to have to prove that it was that the defendant told a lie about them, and further, not only did they tell a lie, but they did so with the intent of causing damage to the to the plaintiff's reputation. So the second thing the plaintiff is going to have to prove: publication, and then fault and damages. Fault's not on there, but it should be. And so damages, there's two types of damages. There's general and specific. So general damages are things like humiliation, mental and physical suffering as a result of the lie. So, if somebody tells a lie about you that's bad enough, maybe you don't want to go out in public for, a few days or weeks or whatever. And so those would be general damages. You should be compensated for your mental anguish in that case. As opposed to special damages, are damages directly related to that lie. So let's say that the lie told about you kept you from getting a job or a promotion. It's pretty easy to affix a monetary value to that type of a lie. So I've got two example cases for you. One's pretty old and one is more recent. So the case that is kind of one of the hallmarks in terms of libel, at least in a sporting context, pertains to a former athletic director at the University of Georgia, as well as Bear Bryant. So the story here, the case comes from 1967. And so what happens is that there is this salesman, I don't remember what he sells, but his general classification, he's described as a salesman. And so he's trying to make a long-distance phone call as part of his work. And so in the late 1960s, sometimes when you're making those phone calls, you'd have to go through an operator and a switchboard. And so they would have to connect you to whoever it is, like manually connect you to whoever it is you were trying to call. And so as part of that connection, sometimes you would inadvertently get connected into phone calls that you didn't intend to. And so you'd overhear other people's conversations. And so when this salesman is trying to make a call, he gets plugged into somebody else's conversation. And so, because he's nosy, he sits there and listens for a few moments. And while he does, he starts to figure out that the two parties that are talking are Wallace Butts, who is the then athletic director at the University of Georgia, and Bear Bryant, who is the then head football coach at the University of Alabama. And both of those two schools are getting ready to meet that Saturday. And so, according to this salesman, what he overheard was the Georgia athletic director, Butts, giving away the Bulldogs' game plan to the Alabama head coach. And so he then tells this story to the Saturday Evening Post. And the Saturday Evening Post takes him at his word that this is what he heard. And they run the story that says that Georgia's athletic director gave away Georgia's game plan to Alabama just before the game. So if you're the Georgia athletic director, you can imagine that's something that's defamatory. So somebody essentially alleged that you sold out your school and you tried to make them lose to a bitter rival by giving away your own team's game plan. So Butts is able to show that that is not what happened, that was a lie. And further, so there's a little bit of a complication here, which is this concept of a public figure. And so if somebody is a public figure, then they have to prove, again, that the defamatory statement that was published was done with malice or ill will. So the statement was made to try to hurt that person. So sometimes that gets waived. And where this gets really fuzzy is who is a public figure. So for example, am I a public figure? I don't know. I have a YouTube channel, as you know. I'm in front of hundreds of students in a good year every semester or every year, and all of those kinds of things. So potentially, arguably, I could be a public figure. Somebody like Aaron Rodgers is obviously a public figure, and so it becomes a question of, is the Georgia athletic director a public figure or not? So the court found that he was, and so then he had to show that what was published about him in the Saturday Evening Post was published with malice. And so the court agreed that what was said about him was in fact published with malice, because basically the Post didn't really follow normal journalistic practices. They didn't try to verify the story. They didn't contact him. I don't think they contacted Alabama. They just kind of ran with the story. And so because that is so unusual, they found the court found in that case that amounted to malice. So as far as damages go, so obviously there'd be some pain and suffering associated with that lie, so humiliation of your butts. But in addition to that, because of that lie, it's pretty unlikely anybody else would hire Butts as an athletic director if he decides, you know what, I'm done at Georgia, I want to go work at Michigan or somewhere else. Based on that story, it's pretty unlikely anybody else is going to hire him. And he might lose his own job because of that lie, right? And so the special damages associated there that's going to keep him from getting another job and potentially could cost him his own. And so what he would sue for then is that opportunity cost from not being able to get another job. Or if he lost his own job, he would probably sue for damages related to his current salary. So those are your general and special damages. A more contemporary case, because again, that one came from 1967 when there were switchboards. You can see Ryan Howard there on the right side of the screen. He's retired now, but at the time, that's when he was playing for the Phillies. So a more recent example comes from December of 2015. The Al Jazeera News Network published a documentary called On the Dark Side. And in that documentary, there was a guy named Charlie Sly, who I think is best described as a trainer. I'm not exactly sure what his role is. But Charlie Sly, on that documentary, alleges that Peyton Manning received human growth hormone from an Indianapolis anti-aging clinic. And of course, human growth hormone is not allowed in the NFL. In addition to Peyton Manning, alleging that Peyton Manning was using HGH, it was also alleged that Ryan Howard, who's the guy that's pictured there, then of the Philadelphia Phillies, and Ryan Zimmerman, who is, I think, currently still with the Washington Nationals, that both of them were getting growth hormone from that same anti-aging clinic. So in January of 2016, both Howard and Zimmerman filed defamation suits against the network. And the reason that's important, there is this sort of colloquial assumption that if you file a lawsuit, it is more likely that you are innocent, that it's a lie that has been told about you. And the reason for that is because, as you remember from the first module, that we talked about the stages of the trial process. Remember, there's pre-trial, trial, and post-trial. And one of the things that happens pre-trial is discovery. And so remember that what happens in discovery is both sides, the plaintiff and the defendant, try to come up with as much evidence as possible. And that evidence, or their attempts to gather that evidence, is backed by subpoenas. So it's backed by the legal force of law. That was redundant, but it's backed by the legal system. So it's enforceable. So, in that case, what would happen during discovery? I might have said deposition. What would happen during discovery is that the defendant's lawyers, so Howard's lawyers or Zimmerman's lawyers, would try to get their hands on the records from that anti-aging clinic, and so would the plaintiff's attorneys. And if the plaintiff's attorneys are, they are the plaintiffs. Messed you up there. Messed myself up there. So Howard and Zimmerman then are the plaintiffs. They're going to try to get their hands on the records from the anti-aging clinic, and then so are the defendants, because Al Jazeera is going to try to prove, no, it's not a lie. They're going to try to prove truth, that it's not a lie because we can show from the records from the clinic that they visited, and not only did they visit, but they were also prescribed human growth hormone. We can show, we've got tapes of them visiting the facility from security cameras. We've got their cell phone data, all those kind of things. So the network who is being sued, who are the defendants, would try to show, they try to prove truth, they try to show that Zimmerman and Howard were there. And so the assumption is that if you don't file the lawsuit, it's because you don't want to go to discovery, because the defendant, whoever you're suing, may be able to prove truth. So because Howard and Zimmerman filed a lawsuit, there is some sort of public assumption that they probably didn't do what they were accused of doing. As an aside, Peyton Manning never did file a lawsuit, and so there's sort of a public assumption that potentially there was some truth there. And as far as I know, I think I last checked in the spring of 2020, might have been fall of 19, but recently I checked, and it looked like that lawsuit was still ongoing, or both of those lawsuits were still ongoing. And then just to add a little bit to that, because I have some of the wording from the complaint, Zimmerman's complaint, in that complaint, his attorney said, quote, due to the defendants, meaning Al Jazeera News Network and Charlie Sly, due to the defendant's defamatory statements, Mr. Zimmerman has been at the center of a media storm speculating as to his alleged use of Delta-2 and other performance-enhancing substances. Mr. Zimmerman's reputation for honesty, both generally and as a competitor, has been called into question, not only in front of the athletic community, but in front of the public at large. And so you can see a few things are happening there. One is they talk about his reputation. They specifically use that wording because, again, they're going to have to show that the reputation was harmed. And they talk about his reputation for honesty, both generally and as a competitor. So they're setting up general and special damages. And further, that his reputation was called into question in front of the athletic community, but also the public at large. So again, by doing that, they're trying to bolster their case for damage to reputation. Not only was it his colleagues in professional baseball, to whom his reputation was damaged, but also the fans of the Nationals or the fans of the Phillies, those kinds of things. All right, so that's enough about libel. On to slander. So again, the difference between the two, slander is spoken, and the plaintiff is going to have to prove the same four things that we talked about on the first slide. So they're going to have to prove that a false statement was made, this time verbally, that there was publication of that false statement, that it was heard and understood by others, that there was fault on the part of the defendant, so they either intentionally lied or they didn't care if they were, and then that there were damages to reputation. It's a little harder to prove reputational damages with slander as opposed to libel. We tend to give the written word more weight, and so it's easier to prove that there was damage to reputation with libel as opposed to slander. So that's that second bullet point, that injury is not presumed. That is unless you accuse somebody of things that fall under certain categories, I guess is a way of saying that. So slander per se means if somebody tells a lie about you related to your sexual habits, related to your qualifications for your job, those kinds of lies are presumed to damage your reputation, and so it becomes easier for the plaintiff to prove that their reputation was injured. So that's slander per se. So if somebody says lies about you that fall into those categories, then injury to your reputation, there we go, is presumed. So the first one falling under slander per se is a crime of moral turpitude. So a crime of moral turpitude is pretty loosely defined. It is basically that somebody accuses you of doing something that is vile, base, or depraved, to use the specific legal wording. Now, what is something that is vile, base, or depraved? I don't know. The typical example I go with because it is certainly would fall under those categories, would be if somebody lies about you and they accuse you of having relations with an animal. So in doing that, that is, with that lie, that is illegal, but also that somebody accusing you of that, if a third party hears that, they are obviously going to think that that is vile, base, or depraved. So you are being accused of a crime of moral turpitude, right? And so that would obviously be something that would damage your reputation. But other things that would fall under there, maybe some more, trying to find a nice way of saying this, some unique sexual practices or those kinds of things. If somebody tells a lie about you related to your habits in the bedroom, that might be something that would fall under the category of crime of moral turpitude. So another one on there, if it affects your ability in your profession. So let's say we'll go back to you using me as somebody recommending you for admission into grad school or for a job. Let's say I lie about you and I say, you know what, I think they cheated on their physical therapy licensure exam or something of that nature. So that lie would obviously keep somebody from hiring you, or would probably keep somebody from hiring you, and so that would affect your ability in your profession. So if there's a lie told about them with regard to their education, their qualifications, how morally forthright they are in their job, if I allege that you were skimming from your previous company when you weren't, then that would obviously affect your ability in your profession. And then loathsome disease, those are your sexually transmitted infections. And so the Ben Johnson scenario from a few minutes ago, that would fall under Charlie Francis accusing Johnson of having a loathsome disease. And then the bottom one on there, sexual misconduct. So somebody lied and accused you of engaging in non-consensual sexual activity, things like that. That would be slander per se. All right, so not a ton of examples in sports, at least not a ton that I'm aware of. So one of the more recent ones that I am aware of, though, is the picture in the lower right. So the gentleman standing up facing toward the camera, his name is Charles Oakley, and he's a former professional basketball player. He played, I think, most of his career, at least, for the New York Knicks. And so he still lives in New York, as far as I'm aware, and he still goes to Knicks games. So when Oakley played for the Knicks, their owner was a guy named Charles Dolan. Well, Charles Dolan no longer owns the Knicks. I think he's passed, but he transferred ownership of the team to his son, who's a guy named James Dolan. And James Dolan is not popular, to say the least. So the Knicks, I think this most recent basketball season, some of the fans would chant things like "sell the team," and they would hold up signs to that effect. So the Knicks have been bad for a long time, and people generally don't like the current owner, James Dolan. And so included in that crowd is Charles Oakley, one of the former Knicks players. And so what you're seeing in that picture is an incident that happened in February of 2017. And so what happened is that James Dolan had Charles Oakley forcibly removed from the arena during one of the games. And so what Dolan says, or the incident according to Dolan, is that so Oakley is at the game, sitting a few rows behind Dolan, and that according to Dolan, Oakley was taunting him and interfering with Dolan's ability to enjoy the game and the ability of others to enjoy the game. So Dolan has Oakley forcibly removed, which again is what you see in the picture there. In a statement after that happened, the Knicks said, quote, we hope he will get some help soon, end quote, as part of a larger statement. And so by saying we hope he will get some help, they're implying that he has something wrong with him, right? He may have some substance abuse issues. He may have mental health issues. Who knows what he's got going on. But they're implying very strongly that there's something wrong with him, so we hope he seeks professional help. Then, in a radio interview later in the week, James Dolan, again the current owner, during the course of that interview says, quote, Oakley may have a problem with alcohol. We don't know, end quote. So making it a little more, they're honing in on the point here. So they're not accusing him of mental illness. They're more specifically accusing him of alcohol abuse. And so in response to that, Oakley sued Dolan, I think, and the Knicks organization for slander, because it was spoken, right? And so with that, obviously, somebody accusing you of being an alcoholic, that would damage your reputation. Potentially, that would affect your ability in your profession. If people think that you have an alcohol abuse problem, they're going to probably assume that you can't do your job well, you may not show up on time, you might be, we'll go with that. Can't do your job well, might not show up on time, those kinds of things. So, like I said, as a result of those two statements, Oakley ended up filing a lawsuit. So as far as I know, that one's still ongoing. No resolution there because the legal system works slow. But as mentioned, that's one of the few cases of slander that I'm aware of that is ongoing in sports. All right, so defamation defenses, we've touched on both of those. So if you get sued for defamation, the first thing you're going to try to prove is that whatever it is that you said is true. And if you can show that, then the plaintiff loses. The other one on there is privilege. So again, the primary, avenue of privilege is the concept of opinion. So, for example, if I were to say that Matt LaFleur, the current head coach of the Green Bay Packers, if I were to say that guy sucks, and he were to sue me for defamation for saying that, or for typing it on Twitter or whatever, right? If he were to sue me for defamation for that, what I would say is two things. One, that's an opinion, that's not a lie. And then the other is that he's a public figure, so even if it was a lie, he would have to prove that it was said with malice, that I said that he sucks, intending to harm his reputation. Now, for the record, I don't feel that way. Packers did pretty well last year, so hopefully they'll do well again this year. But where that would cross into something that would be defamation is, let's say rather than just expressing an opinion about the head coach, instead I Photoshop him in with a picture of some lady, and then I start a rumor on social media where I say that he was pictured with this lady outside of a bar, he's probably cheating on his wife, I heard they do all kinds of awful things. Something like that, right? So I'm throwing in multiple lies. So if I know those are lies and then I post them on social media, I'm probably doing it with the intent of hurting his reputation. And so in that case, that's not something that is an opinion. That is me intentionally concocting a lie. And so because of that, that's something where I could be held liable for that. But you are protected if you just say, they're terrible. If you're just expressing your opinion, then that is protected. All right, so to shift gears pretty significantly, so away from defamation, into land ownership. So as a landowner, you may bear some liability for your property when somebody gets injured on it. So where this comes up, a few places fairly commonly. So one of those places is, both of them, Parks and Rec, related to ball fields or other facilities that you own. So sport courts, fitness centers, those kinds of things, the landowner can be responsible for injuries that occur on their premises. So the key here is that if somebody is injured as a result of something wrong with your land or your facility, one of the big questions is going to be, was that defect, whatever is wrong with that facility, was that open and obvious? And so what that means, as you can see on there, is if a user, through reasonable use of one's senses, can detect that defect, then that's an open and obvious risk. So to make this a little bit more concrete, one of the cases we talk about sometimes is a woman who is injured in the course of a recreational softball game sliding into third base. And she actually breaks her ankle. So what ends up happening there is that the plaintiff in that case, the woman who gets injured, she was at the very least a high school softball player. I think she also played in college. And then after graduating from college, she played a bunch of recreational slow pitch softball. So she goes one night to play a recreational game. The weather's been terrible all day. It's been raining, and there was a game before them. And so with all of those factors combined, there was a fairly large hole on the first base side of third base, if that helps you. So if you're looking from home plate to the right side of third base, there's a big hole there. And so when she slid into third base, she caught her ankle in that hole and she broke it. And so then she turned around and sued the city that owned the fields and said that the defect in their land caused her injury, and so as a result, they were liable. But because she was an experienced softball player and she had actually talked to the umpire before the game about that defect right by third base. She was aware that the hole was there, and she chose to play anyway. That actually falls under assumption of risk. So if whatever is wrong with your property is open and obvious, that somebody can see it through their ordinary senses, they can see it, hear it, feel it, touch it, using their ordinary senses, then that is something where if you choose to participate in spite of that, then you have assumed the risks. And so the court in that case found for the city, found for the defendant, because she was, again, an experienced softball player, noted that the hole was there and chose to play anyway. And so since she was injured due to a defect she knew to be there, that falls under assumption of risk. She chose to play when she didn't have to. That's as opposed to if there is some sort of risk that is not open and obvious, then the landowner has a duty to warn about that risk. So there's a few cases. I don't think we'll have time to get to probably any of them. But one of them I'd actually talked about in the previous lecture, and that was related to the high school, the Catholic school in Connecticut that hosted a track meet, and their long jump pit wasn't the normal concrete rectangle, but instead was cordoned off by boulders. And that, remember, one of the boulders had rolled into the pit, and somebody had actually just raked sand over it. And so if you are participating in the long jump and that boulder is covered up by sand, well, you can't see it. That's not an open and obvious risk. And so the user, or the athlete in that case, can't consent to the risk of jumping into a pit that may or may not have boulders in it. Because that was not an open and obvious risk, because it was actually covered up by sand, then that's something that the landowner has to warn about. There's a case that comes from upstate New York from the mid-2000s where some day campers were at this state park, and they go into this park along a river, and there had been a bunch of rain in the days prior to their visit, and so the river was up much higher than normal, and they had gone off trail to a swimming hole sort of downstream from the main swimming hole that everybody used, and so there were some rapids around that swimming hole, and so one of the camp counselors, one of them jumps into the water and gets pulled underneath. And so then somebody else jumps in after him, trying to save him. Somebody else jumps in after, and then a fourth person jumps in. All of them get sucked underwater and end up drowning. And so then the families turn around and sue the state and essentially say that risk was not open and obvious, that there was such a strong whirlpool there, and so that the state had a duty to warn. Ultimately, the state is successful in that case. But so if there's some sort of a risk that's not open and obvious, you have a duty to warn about that risk. All right, so shifting gears again. So to false imprisonment. So false imprisonment is where you confine somebody against their will. So you can see what the plaintiff is going to have to prove there. That the confinement actually occurs, somebody held you somewhere against your will, that the defendant intended for that to happen, so they acted in some way that caused confinement, and then the person who was confined was aware of it or harmed by it. So one of the most, let's go with notorious cases, where false imprisonment could have come up is related to the guy there in the lower right with the ball. His name is Adam James, and he's a former tight end for Texas Tech University. And so what happened was during football practice, or during practice for the bowl game for Texas Tech in 2009, as they're getting ready for their bowl game in the Alamo Bowl that year, Adam James suffers a concussion. And so he shows up to practice one day, and he has sunglasses on, and the head coach at the time, a guy named Mike Leach, who after Tech moved to Washington State, and this most recent year, in the fall of 2020, he's going to be at Mississippi State. But at the time, Mike Leach is at Texas Tech, and when Mike Leach sees Adam James walk out onto the practice field with sunglasses on because he has a concussion, Mike Leach is incensed about this. And so he tells the athletic trainer, look, if he is light sensitive, go put him somewhere dark. And so the athletic trainer takes James into the inside of the stadium, because they practiced at the time, and I think they probably still do, in their game stadium because they have turf. And so the athletic trainer takes James inside or underneath the stadium and puts him into an electrical closet where it's dark. And so James then takes a video of that and he sends it to his dad. I don't know if that's his dad there, but I'm going to show you the video that he sends to his dad. So it's quick. It's, as you can see, only 15 seconds, but this is the video that Adam James shot while he was in the electrical closet. So he said, I turned the lights on real quick, so I got to be fast. So when he sent that video to his dad, what he was saying was that he'd been locked in this closet and he had to keep the lights off, you know, because he was photophobic. He was sensitive to light at that time, and so he was locked in this dark electrical closet, sort of as punishment for having a concussion. Now, Adam James, his dad, was a guy named Craig James, who's pictured there. So that's Craig James. If you know anything about Craig James, he was an analyst on ESPN's college football. In addition to that, the other fun facts about Craig James are that he played for SMU, Southern Methodist University. He was a running back for SMU in the early 1980s. And he was instrumental in getting them the death penalty. So SMU had to disband their football team as a result of players taking direct cash payments and doing so repeatedly. And so Craig James was one of the guys who helped them helped cause their death penalty getting. There's a better way of saying that. But played an instrumental role in the university getting the death penalty. So, but anyway, he was able to parlay that into a successful broadcasting career with ESPN. So when Adam James sends this video to Craig James, Craig is just out of his mind, upset about this, and so he then calls the chancellor at Texas Tech and says, here's this video, can you believe this? Mike Leach needs to be fired. And so ultimately Mike Leach gets fired. But the interesting part about this, so what's going on there is you've got false imprisonment. You've got Adam James is locked in an electrical closet, so the confinement actually occurs. In this case, the athletic trainer put him there, so that act caused the confinement, and so obviously he was aware of it. It would be difficult to argue he was harmed by it, but certainly at the very least he was aware of it. So the trouble with this, of course, is that it ends up going to becoming a legal case and going to discovery. And the reason it becomes a legal case is that after Mike Leach is fired, he actually turns around and files a wrongful termination suit. And I think he also files a defamation suit because it didn't happen that way. So effectively what happened is that Mike Leach really didn't like Adam James, and I think the feeling was mutual. And so during bowl practice, a few days before the concussion incident, Adam James was having a terrible practice, wasn't really trying, and so Mike Leach gets mad at him and says, okay, well, if you're not going to try during practice, you need to go over to what they called Muscle Beach. And what that is a special conditioning session with a strength and conditioning coach. So those are all the guys that are injured. You know, so they have a lower body injury, they just do all upper body stuff. And then if guys aren't giving their all in practice, then they have to do punishment stuff. So they have to like run stadium steps, or they do push-ups or burpees or whatever other punishment he wants to put them through. Basically, Adam James refused to be punished. He just kind of danced up and down the stadium steps and laughed through it all and didn't take it seriously or any of that kind of stuff. Then, a few days later, he shows up to practice late with his street clothes on. So rather than any of his Texas Tech stuff, he shows up wearing his street clothes. He's got a ball cap on backwards, and he's got sunglasses on. And Mike Leach sees him come out on the field, and the athletic trainer is near him. So Mike Leach is like, what's the deal with him? Why is he out here like that? And so the athletic trainer is like, I don't know. He went to the team physician. The team physician diagnosed him with a concussion, so I guess he has a concussion, and apparently he's sensitive to light. And so Mike Leach says, okay, well, if he's sensitive to light, get him off the field, put him somewhere dark, because essentially he's gonna hurt our team morale if he's out here just standing around like that. I don't want him around, and so especially if he's sensitive to light, just go put him somewhere dark. We don't have to worry about him. So the athletic trainer takes James inside of the stadium, and he puts him in the media room where people will watch film, and he specifically tells James not to go into the closet. So what ends up happening is that James goes into that electrical closet, pretends that he was locked in there, shot that video and sent it to his dad. So all of this that happened is based on a lie. It is James trying to get at the then head coach, Mike Leach, and also the rest of the Texas Tech staff. And so it comes out during discovery that what James did was a lie, and so there was never false imprisonment. None of that ever occurred, or at least his confinement never occurred. He was just supposed to be hanging out for 2 hours in the media room, and instead he chose to pretend that he was locked in an electrical closet. So, as you can imagine, false imprisonment, relatively rare. So I don't know of any cases specifically that actually happened, not ones that were based on a falsehood. The only one I could come up with, in talking to a friend of mine who was a high school coach in Texas, and still is, but he said early in his career that he was coaching high school basketball. I think actually he was coaching freshman basketball in the suburbs of Houston. And so his freshman basketball team was one day just in the locker room. They were just absolutely messing around, and the whole place was trashed, and they had no intention of going out and having a good practice that day. And so the way their locker room was set up, you basically had each team, so like the freshman team or the JV team or the varsity, they all had their own little separate locker areas. And so the freshman locker area, for example, had a gate that slid across it, and then you could lock it. And that way, you could make sure that nobody's stuff got stolen, because you would just lock when the cubbies or when the lockers weren't in use, you just lock all of them up with this gate. And so what this guy did was because he was upset with them because they weren't, like I said, they were just messing around. They weren't going to practice. So he slid the gate closed and locked it and said, okay, well, if you guys don't want to practice, we're just going to hang out here. And so he just sat there. I think he pulled up a chair and sat there and watched them. And so as he's doing this, the assistant principal happens by and says, hey, what are you doing? So he explained, and so obviously then he opened the gate, and my good friend got suspended for 3 days, rightly so, which he admits. That was not the smartest move to do, but arguably what he had done was false imprisonment. So he confined those players to their little locker area. He intentionally caused their confinement. He closed the gate and he locked it. And so obviously those players then were, at the very least, aware of their confinement. They weren't harmed by it, but they were certainly aware of it. So potentially there could be a false imprisonment case there. All right, so let's talk about intentional infliction of emotional distress. This one is also pretty rare in a sport context, as you might have guessed, based on the fact that the case I'm going to tell you about comes from the 1960s. So in order to prove intentional infliction of emotional distress, you can see that the plaintiff is going to have to prove there. So the plaintiff will have to prove that the defendant engaged in extreme, outrageous conduct, that the intention by the defendant was to cause severe emotional distress, or reckless disregard for the probability that emotional distress would occur. And the defendant's conduct, so this is kind of a but-for test, the defendant's conduct must be the cause of that emotional distress, and then damages. And so the distress that was caused must be severe. It can't just be that you cause somebody to be anxious or stressed out for a little bit. It has to be really severe distress that they endured as a result of the behavior of the defendant. So this one is probably best explained through my example. So the guy pictured there in the lower right, his name is Don Chewy. And in 1969, he was in his 7th season as a professional football player. So he played in the, that would have been the NFL, I believe, because that was before the merger. So at any rate, he's in his 7th year of professional football, plays for the Philadelphia Eagles. And during a game when he's blocking, because he's an offensive lineman, couldn't remember if I said that, he hurt his shoulder. And so after hurting his shoulder, he doesn't return to the game. And then after that game, where he comes out because of a shoulder injury, he goes and sees the team physician. The team physician gives him an injection, probably a corticosteroid, and clears him to return to play the next week. But Don Chewy doesn't feel normal, doesn't feel like he can play, so he doesn't play the following week. Then, after skipping that second game, he ends up going into convulsions and throwing up blood. And so as you can imagine, then he seeks emergency care, and there's a diagnosis done on him, there's blood work done on him, and so his own physician concludes that Don Chewy has a condition, and I don't know what they actually diagnosed him with, but the gist of it is that he is predisposed to blood clots. That would be worse if he engaged in contact sports. So I think what he had was actually a pneumothorax. I think he probably had a spontaneous not pneumothorax, wrong. Pulmonary embolism, that's what I was looking for. So he had a blood clot around his lungs. I think that's what he actually had. So as far as the clotting disorder, I don't know exactly what they were diagnosing him with. But nonetheless, the gist of it was that continued participation in professional football would be ill-advised because it would make him, in the opinion of this physician, it would make it more likely that he would have more blood clots, and so you might get a worse outcome. So his physician advises him to retire. So an important thing to know is that arguably that is football related or exacerbated by football, made worse by football. And why that matters is because professional football contracts at the time were structured so that they were always 3-year contracts. The whole thing was regarded as a 3-year contract, but effectively it was a 1-year contract. And so if somebody had to stop playing because of something football related, well, then the team owed them the remainder of the contract. But if the reason they had to stop playing was unrelated to football, or if they got cut, then the team didn't owe them the remainder of the contract. So the fact that Chewy's diagnosis meant that his condition was made worse by playing football, and therefore he couldn't continue to play football, meant that the Eagles owed him the 2 remaining years on his contract. So they owed him, I think, $60,000. Professional football then very different than now. So they would have owed him $60,000. And so what ends up happening is that the team physician for the Eagles, the guy named James Nixon, goes to the press and tells them that Don Chewy won't be returning to the team, but because he's been diagnosed with a blood condition. However, Nixon tells the press that Don Chewy has been diagnosed with polycythemia vera, which is blood cancer. So at the time, that carried a prognosis of 12 to 18 months. And so he tells the press this. Chewy lived in LA, so Chewy actually reads about this in the newspaper, that the Eagles doctor says he has blood cancer and is going to be dead in 12 to 18 months. And so as you can imagine, that causes some pretty severe emotional distress, that he's been told he only has a year to year and a half to live because of this blood cancer. And so he calls his doctor, who says, you know what, come back, we'll do some more testing. I don't think that's right. And so Chewy says no. He's just so distraught. He basically just kind of goes into a shell and lives, goes into his room, doesn't leave his house for long periods of time. He's, again, just inconsolate. He just can't console him. He's so distressed about this. But it turns out, so after about 8 months of waiting to die, Chewy, his physician, finally convinces him, look, just come in, we'll do some more testing, maybe we can do some treatment, but certainly let's do some more testing. And so they do, and it turns out the original diagnosis was more correct, that he did not have blood cancer, didn't have polycythemia vera, and so he wasn't going to die in the next year to year and a half. So he turns around, he being Chewy, turns around and sues the Philadelphia Eagles, and more specifically, their physician, James Nixon, for intentional infliction of emotional distress. And the reason that Nixon told the press that Chewy had blood cancer is because by saying that he had a condition that was not made worse by football and not caused by football, the Eagles wouldn't owe him the remainder of the contract. So they wouldn't owe him that remaining $60,000. So he told the press that to keep the Eagles from having to pay out that $60,000. So in terms of the elements that Chewy would have to prove, was there extreme, outrageous conduct on the part of Nixon? Yeah, absolutely. If a physician goes to the press and releases a public statement about you that's a lie, that you're going to die within the next year when he knows that's not the case, that seems to meet the criteria of extreme and outrageous conduct. Second thing there, was it the intent of the defendant to cause that emotional distress? Not necessarily, but at the very least, was there reckless disregard for the high probability that emotional distress would occur? Absolutely. So it wasn't that Nixon intended to cause Chewy emotional distress, it was that he didn't care if he did, or that it was likely that it would happen. The third one on there, was Nixon's conduct the cause of the emotional distress? Yeah, absolutely. What he told the press is what led to the severe depression on the part of Chewy. And the last thing, damages, he, like I said, he basically didn't leave his house for 8 months, and so obviously there were some pretty significant damages there. Presumably to relationships with his family, but also career prospects, those kinds of things. And so that would meet the criteria for intentional infliction of emotional distress. So as you can see, it's pretty hard to prove this one. So people oftentimes kind of throw this one in lawsuits just like as an add-on, like, oh, also emotional distress. But it's pretty difficult to prove. So you might have guessed that from, like I said, case comes from 1969. All right, so let's talk about invasion of right to privacy. All right, so as you can see there, when we talk about right to privacy, what that describes then is a person's solitude or their right to be let alone. So the idea behind right to privacy as it pertains to tort law is that it's designed to protect against unreasonable interferences with a person's solitude or their right to be left alone. So there is some level of intrusion that we all endure, but if it becomes excessive or unjustified, then that's something that might give rise to a tort, so to become the subject of a civil lawsuit. So as you can see there are 4 areas of right to privacy. The first one is appropriation of one's name or likeness. So if you appropriate it, basically you are stealing or reusing one's name or likeness. And so my example related to that is the graphic I have on the right, Michael Jordan's Steakhouse. So let's say I decide I'm going to open up a new restaurant in Whitewater, and I'm going to name it Michael Jordan's Steakhouse. That's the text and font I'm going to use, even though my name is obviously not Michael Jordan, nor do I know anyone named Michael Jordan. That's just what I'm going to call it. And so in doing that, what I'm trying to do, and this also crosses over with intellectual property law that we'll get to later in the semester, but probably the reason that I'm doing that is I'm trying to capitalize on his reputation. And on the goodwill that people feel toward Michael Jordan. And so if you think this new restaurant that I've opened up is owned by Michael Jordan, then maybe you're more likely to patronize it than if it was just Jason's Steakhouse, right? So if you appropriate somebody's name or likeness, what you're doing is you're trying to use some attribute of their name or a picture of them to profit from. So you're trying to, like I said, capitalize or profit from their reputation. So a question I have for you then as an add-on to that is, am I invading Michael Jordan's privacy by using this picture on my slideshow? And of course the answer is no. And the reason I'm not is because I'm not generating any profit from using his name like this. This is educational, used for an educational purpose, which is covered under, as it pertains to intellectual property, covered under fair use. So this would not be appropriation of his name or likeness because I'm not using it to profit from it. However, if I were trying to capitalize on his reputation to generate profits for myself, then that's something that would fall under misappropriation of one's name or likeness. So we see this, if I were to, I start a new line of supplements. So I start a new line of protein powders or something like that. And I just use pictures of all the top bodybuilders or all the top strongmen in my ads, even though I haven't secured their permission to be in my ads. One of the ways they could sue me, or one of the areas under which they could sue me, is invasion of right to privacy, and they would allege that I have misappropriated their name or likeness and I was using them to profit off of. I was trying to sell more of my supplements by creating a false association between my supplements and them. I was trying to insinuate that they use my supplements, which then played a role in them being top strongmen or top bodybuilders. The next one on there is intrusion. And so intrusion is where somebody violates your personal space, basically. So it is, for example, invasion of your home or your personal belongings without permission. So somebody goes through your stuff or they come into your house. One of the few cases I could think of that's related to this in a sport context deals with Erin Andrews, a sportscaster. I forget which station she's with now or which network. I think she's with Fox now, but she was with ESPN. And so she's a really famous broadcaster, generally does sideline reporting as far as I'm aware. And so there was a case a few years ago where I want to say it's like 2014-ish, but she had a stalker, and the stalker was able to call the hotel where she was staying in Nashville for a game. And then he said, okay, well, what room is Erin Andrews in? And amazingly, they told him. And he said, okay, well, I want the room right next to hers. And so they booked him the room right next to hers. And then when she was out, he remove the peephole from her room, that you look out to see who's knocking on your door. He removed that, and he inserted a camera in its place that was facing into the room. And so he was able to videotape her when she was getting in and out of the shower, and obviously she was undressed for various portions of that, and so he then put that on the internet. And so that led to a really high-profile lawsuit, and so part of that was intrusion, that he obviously invaded her privacy with that. And as you can imagine, she was successful in that suit. The next one on there is false light, which is similar to defamation, except that what you're saying is not outright false. You are insinuating something that may not be true, but you're not saying something that's an outright lie, because then obviously that would be defamation. So, for example, if there was a picture of Aaron Rodgers with some young lady, and the caption in the newspaper was, Aaron Rodgers seen about town with somebody who is not his girlfriend. So that is true, right? It's him in a picture, and maybe they were out having dinner, having a meeting, whatever. So there's some truth to it, but the insinuation there is that he's doing something that he shouldn't. So it's casting him in a false light. So again, similar to defamation, but you're not saying something that's an outright lie. And the last one on there is public disclosure of private facts. So in that case, what you've got is publication of facts that are private, that would cause embarrassment and humiliation, that are not a legitimate concern to the public. So one of the cases related to that that I can think of, that I'm familiar with, comes from the late 1990s with the Texas Longhorn basketball team. And so that year, the Longhorns weren't doing very well. I want to say it's 98. The Longhorns weren't doing very well that year. The players didn't really like the coach. The coach is kind of, on the bubble that he might get fired. And so the players wanted to get rid of the coach, and so they held a players-only meeting, and then they had a meeting with the athletic director seeking removal of the coach. And the leader of the player group was a guy named Luke Axtell. And so what happens is that the head coach, as you would imagine, hears about this, and so when he gets back, he suspends Axtell and some of the other players for not making good academic progress, basically. He says that they're not doing well in the classroom, so he suspends them. Which looks really suspicious, that they've had this meeting with the athletic director trying to get him fired, and then all of a sudden when he comes back, he suspends those players. And so to sort of bolster his argument, he has one of his assistants fax the grades, because this is the late 1990s, he has one of his assistants fax the grades of Luke Axtell, the leading player, to a radio station in Austin, so the home of the Texas Longhorns. So faxes the grades to this radio station in Austin, and the radio station is the one that carries all the Longhorn games. And so those grades were read live on air that Luke Axtell had recorded. They basically just read his transcript out to all the listeners that morning in Austin. So, as you can imagine, that would fall under public disclosure of private facts. There's no reason for the public to know Luke Axtell's grades for that semester or any other. And so then that's also a violation of something of FERPA, Federal Education Right to Privacy Act. So it's a violation of that as well, but as it pertains to this, that would fall under the category as well of public disclosure of private facts. So again, it's basically something that, it's not necessarily a secret, but it's not something that the public needs to know, and so it's a disclosure of that. All right, so click to the next slide, maybe. There we go. So a contemporary example I have for you, possibly, is a Wisconsin example. So if I were to tell you that Trek Bicycles, which is based in Waterloo, Wisconsin, which is about 30 miles from Madison, which you probably knew, but I had to look up, that Trek Bicycles last year, I think 2 years ago now, I think in the summer of 2018, they came out with a new line of fat tire bikes. And you can see the ad here. This would be a print ad for them that says Super and Fat. And the name of the line of bikes was Farley. So they are Farley fat tire bikes. So a question I have for you then is there anything else that you associate with Farley? Now, the reference is getting pretty dated at this point, but there's a famous comedian, named Chris Farley, the guy there on the right, who was a Madison native. Grew up in Madison. He went to school at Marquette, and then most famous for landing a role on Saturday Night Live. And you can see there from that picture, so the skit there, you can find it on, you can still find the video. I think it's on Hulu. But the video is him and Patrick Swayze trying out for a spot at Chippendales. And so his family sued Trek Bicycles, alleging that they misappropriated his name. Basically, that they were trying to capitalize on Chris Farley's reputation and his comedy. And what they describe his comedy as is something to the effect of a very specific brand of fat guy comedy, right? And so if you know anything about him, and you can kind of tell from this picture, so when he's trying out for Chippendales dancer, he's rubbing all over himself, and he's jumping on the floor, and he's taking his shirt and running up between his legs and all kinds of stuff. And so it's obviously ridiculous because he doesn't have the physique that you would assume somebody working at Chippendales would. And so that was kind of his brand of comedy, was making fun of his size, right? So he's sort of a fat guy comic and did a lot of physical comedy. He also was in movies like Tommy Boy and Black Sheep, lots of him falling down and that kind of stuff. That was his brand of comedy. And so the family is alleging that this Wisconsin-based bike company, Trek, is trying to capitalize on the reputation of a Wisconsin native, a famous comedian, Chris Farley, by naming their fat tire bikes after him. They're trying to draw connections between their fat tire bikes and the famous Wisconsin comedian. So this case is ongoing, but if you're interested, like I said, you can find that video. There's some pretty funny clips of Chris Farley. So it'll be interesting to see how it turns out. The family actually sued for $10 million. And like I said, this suit is only, give or take, a year and a half old. So we'll see how that one turns out. All right, let's talk about more intentional torts, trespass to property. So there's a couple things on there. So there's trespass to real property as opposed to trespass to personal property. The key differentiator between the two, when we talk about real property, that's something that's fixed to the land. So that is an athletic field, that would be a pool, some sort of basketball court or racquetball court, whatever. So that's something that is stuck to the land, something that is not movable. That's real property. As opposed to personal property, that's movable. So that would include things like your sports equipment, your sleds, in the case of football. So anything that's movable falls under the category of personal property. So trespass to real property, the defendant was somewhere that they were not allowed to have been. The idea here, and actually let me get to this part first. So it doesn't require actual harm to the property. So you can see my picture there. I've got a guy at a Texas Rangers baseball game running across the outfield. So one of the things that the Rangers might pursue is a civil suit, if they wanted to, for a trespass to real property, because one of the legal concepts undergirding this trespass to real property is the idea that if you own that land, you have the right to control that land, what happens there, as well as who enters and who leaves. Well, not necessarily who leaves, but certainly who enters. So if somebody like this guy just runs across your land without your permission to do so, well, then that weakens your ownership of the land, because you're not really able to control your own private property. And so because of that, they have damaged your control of your own property, and thus that might cause you some damages, right? And so so where that becomes important is that it doesn't require actual harm to the property. So that guy could be liable for a trespass to real property simply by the act of running across the field. Again, because he weakened the owner's claim to controlling that land that they own. Now, if he had done harm to the property, so if you like sneak into a football stadium of your rival football team in the middle of the night and you take an X-Acto knife and cut up their end zone graphics or their midfield graphic or whatever, that's harm to the actual property. And so certainly that would be a trespass to real property. But again, just by the act of being there when you're not supposed to, that can still count as a trespass to real property. So from the standpoint of defenses, there are two. The first one is necessity. So if there's necessity, you have to be on that land to protect yourself. There's some sort of compelling reason that you needed to be on that land. So, for example, if you enter a stadium that is, after hours and it's all locked up, but maybe you entered that stadium to protect yourself from an oncoming storm, right? So then you're doing it for your own protection. That would fall under the classification or under the defense of necessity. Privilege is kind of like we talked about with privilege with assault and battery, that you're protecting something or someone. And so let's say there is say a high school coach is running around a track, but the track is locked up. It's only supposed to be, let's say, school district personnel on that track. And so other people are not allowed in the stadium or on that track at the time. But that coach, let's say they have a heart attack and fall down while they're running their laps, while they're doing their workout on the track. And so in order to help them, you had to scale the fence and be on land you're not supposed to be on to help this coach who's having a heart attack. That would fall under privilege. So you're trying to assist someone who needs your help. So that's the primary thing that would fall under privilege. Trespass to personal property would be if you take something without permission. Now, it's a little bit different than if you actually... So if you just take it without permission, that's trespass to personal property. But if you take it and keep it, i.e. if you steal it, that's something else. That's called conversion, which we won't talk about. But trespass to personal property is just that you took something without permission. The last one on there, disparagement of property. So if you disparage something, you say something bad about it. So there are two types of disparagement. The first one is slander of title. The second is slander of quality. So slander of title, you are questioning whether or not they own that object or they own that land. So for example, if you had somebody that was selling sports memorabilia, sometimes there's stores in the mall where they sell autographed bats and jerseys and that kind of stuff. And so if there was a prospective customer getting ready to go to that store and you pulled them aside and were like, hey, I've heard that what they sell in here is not owned by them. That basically they stole it from another store, and so they don't own it, but they're trying to resell it. So you're questioning their ownership of that memorabilia in that case. Now, you could go the other route as well and say not only do they not own this stuff, which is a slander of title, but I've also heard that a bunch of these autographs are fakes. That's a slander of quality. So if you say something that is untrue about the quality of their products, that could then fall under disparagement of property. So similarly, if you, let's say you're a competing company against Balfour, who's the jewelry company that usually makes like championship rings. So, if you win a conference championship, you'll get a ring that has diamonds in it and the Warhawk logo and all that stuff. And let's say you work for a competing company and you go to the athletic director and you say, you know what, you could buy from Balfour. They are the leader in the business, but I've heard that the diamonds that they use are fakes, and that rather than silver, they use, some other kind of metal, aluminum. Let's go with that. When in fact, both of those things are untrue. So that would be a slander of quality. So slander of title, you're questioning somebody's ownership. Slander of quality, you're saying that the product isn't as good as the owner is claiming it is. All right, last thing, product liability. You're in the home stretch now. We're in the home stretch now. So the public has a right to expect a reasonably safe product. So that's the idea behind product liability, is that we should be able to expect that the products we buy are at least of average quality, that they are fit for the purposes for which they're advertised and the purposes for which they're designed. So, for example, my little exercise bike on there, if that exercise bike had a seat that let's say the pin that holds the seat in place that raises it up and down, let's say that pin gives out if the user is over 150 pounds. Well, the odds are pretty good that people that are using the exercise bike, that they're going to be over 150 pounds, because that's most people. And so in doing that, if you're sitting on that bike and that pin gives out and the bike seat drops, you'll probably hurt your spine potentially, or fall off the bike and sustain some other sort of an injury. And so that's not the type of danger or defect you would associate with using that product. And so if you're injured because of that defective product, well, then you should have the ability to be compensated for that injury for them not manufacturing or not designing a good product. So that's the underlying principle of product liability. So you can see some important terminology there. If something is defective, then it is unreasonably dangerous. And so what does unreasonably dangerous mean? It means that it's dangerous beyond the extent that the normal consumer would contemplate. And so we talked about that some with football helmets. So the idea that football helmets are really, their original purpose was to prevent skull fractures. But most people, when you do surveys, assume that helmets can prevent concussions. And so because the typical consumer of that product assumes that the product can prevent concussions, then because they can't, the manufacturer has a duty to warn about that danger because it's dangerous beyond the risk or beyond the extent that the normal consumer would contemplate. And so as you can see there, everybody in the product chain is potentially liable. So the people that manufacture the product, the people that sell the product, potentially the packagers. Another thing that this book makes note of is that land can be a product. So if you have, earlier we talked about the softball field with the hole in it. So not only could the landowner be liable, but the, let's say the Parks and Rec person who was promoting the league potentially could be liable, the umpires, because they're involved in inspection of the land, those kinds of things. So there's a wide variety of people that can be potentially liable for product liability. Now, will the suit be successful against, the person promoting the rec softball league? Probably not. But does that mean that somebody won't try to sue them? Also probably not. All right, so in terms of product liability, so there is product liability based on ordinary negligence. So those are the same four things that we talked about when we talked about ordinary negligence. So the plaintiff has to prove that there is a duty on the part of the defendant, so on the part of the equipment manufacturer, that they breached their duty, that breach led to the injuries they sustained, and they have to be able to prove damages. So you can see my football helmet warning there again. There was a case that was decided within the last couple of years that was related to the heat stroke death of a former NFL football player. So the player's name was Corey Stringer. He played for the Vikings. He died in 2001 of heat stroke. And his wife successfully sued Riddell, the manufacturer not only of the helmet, but they also manufactured the shoulder pads and the rest of the padding that was worn, I think, throughout the NFL, but certainly by the Vikings at that time. And so what his widow alleged was that the pads made it more likely that the wearer would suffer heat stroke because obviously the padding keeps the heat from escaping, particularly the plastic shell. So it elevates your core temperature faster, so it makes it more likely that you could suffer from heat stroke, and further, that the ordinary user would not assume that was the case. And so because the ordinary user of that equipment wouldn't assume that they were at greater risk of heat stroke, then Riddell had a duty to warn about that risk. And so what she was saying there, what their basic argument was that Riddell had a duty to warn, again, because the ordinary user wouldn't assume that there would be an increased risk of heat stroke, that Riddell breached that duty. They, in fact, did not warn. And because Stringer and the other football players weren't warned about the dangers of heat stroke, that led to their injuries. Maybe, I don't remember the exact case that they made, but maybe that they didn't hydrate as well as they otherwise would have or something to that effect, and then damages. That case actually really surprised me because it seemed like, from my standpoint, and that comes from playing football in Texas, 20 plus years ago, but at the very least, it's hot, and it's hotter with your pads on. So it seemed like the ordinary user would be aware of that, but the courts deciding that case felt differently. So ultimately, Stringer's widow was successful in that suit against Riddell. All right. So we talked about public having a right to expect a reasonably safe product. So strict tort liability, rather than going through the whole duty, breach, causation, damages, one of the routes you can go is with strict tort liability. And so here are all the things that the plaintiff is going to have to prove: that the product was defective in design, manufacture, or warning; that the defendant was in the business of selling such products. So that could be, the company that makes a physio ball, or Dick's Sporting Goods, or Walmart that sells the physio ball; that the product was unreasonably dangerous due to a defect; that the plaintiff was injured, that the defect caused the injury; and then the last one there is that they hadn't modified the product since the time of sale. So I'll give you an example, and this might be on the quiz. If not, I'm giving you the answer. Or if it is, I'm giving you the answer. So there was a case several years ago. I think it was from 2012. I don't know. If it's in the quiz, the year is on there. But there was a player for the Sacramento Kings. I'm flipping through my notes right now to make sure I know the name. Oh, I got the year wrong. So it's 2009. So in 2009, a player for the NBA Sacramento Kings, his name was Francisco Garcia. He was doing dumbbell bench press on a physio ball, much like the one pictured there in the lower right. And the ball that the Kings, or in the set of balls, I guess, that the Kings had bought were from a company named Ledra-Plastic. And so Ledra-Plastic marketed their balls as being, quote, burst resistant, end quote. And so they, in their marketing materials, said that the balls could withstand pressure or withstand a weight of up to 600 pounds. So these would be pretty thick, would be pretty durable, able to hold a lot of weight, which is why an NBA team would buy them. And so Garcia was doing dumbbell bench presses, so laying on his back on the ball, doing dumbbell presses, and he had 90 pounds in each hand. So we're going to assume he was certainly less than 250 pounds. He's holding 180 pounds, so nowhere in the neighborhood of 600 pounds. So that ball should be able to withstand that weight pretty easily, but it didn't. So with him in that position, the ball ruptured. And so you can imagine how much that hurt. He slammed to the ground. And then the dumbbells came crashing down on him. One of them, so as your arm hits the floor, it compressed his forearm bones between his humerus and the dumbbell. And so in doing that, it broke his, I think, both bones in his forearm. I'm trying to see if I have it in my notes. Anyway, he broke his wrist. So in doing that, so then he and the Kings turned around and sued Ledra-Plastic based on this concept of strict tort liability. So let's run through what they would have to prove. So is the product defective in design, manufacture, or warning? At the very least, it was defective in warning because they said that the ball could withstand 600 pounds and it ruptured with much less weight than that. And in fact, the plaintiff's attorneys, so the attorneys for the Kings and Garcia, bought a bunch of the Ledra-Plastic balls and they did some testing on them, and they found that some of them ruptured with as little as 400 pounds. So that's still a lot, but if you're buying them for a professional basketball team or professional football team, they're going to be subject to pretty close to 600 pounds during some different exercises. So it was certainly defective, at the very least, in warning. Ledra-Plastic was in the business of selling those things. The product was unreasonably dangerous due to the defect, because then people could assume that they could load that thing with 600 pounds when, in fact, the ball might rupture with as little as 400. In this case, Garcia was injured. He was injured because the ball was defective, and they hadn't done anything to the ball since the time of sale. So they hadn't, done any modifications to them in terms of, like, I don't even know how you'd modify a Swiss ball or a physio ball, but they hadn't done anything to them. They were right out of the box. They inflated them, and they were playing, and they were using them, right? So in terms of defenses, the company, in that case, could argue contributory negligence, that Garcia contributed to his own injury. So maybe they would have argued that he was bouncing on the ball, and so if you bounce on the ball with a bunch of weight, you could overload it. I don't know what they actually argued. Second one there is assumption of risk, that you understood and appreciated the risks of doing that exercise on that ball. In that case, you can't assume the risk that it's going to rupture at 400 pounds because it said 600. And then foreseeable misuse. So they're saying that you're misusing their product. So obviously Garcia was using their product as intended, as an exercise ball, but you've all seen the videos, on YouTube or wherever else, of people like taking the physio balls and running full speed into each other and then just like rocketing off different directions. If you were injured using one of the Ledra-Plastic balls doing that, that's misuse, and so you would not be successful in a suit against them for any injuries you sustained doing something like that. It's not what the product's intended for. All right, and then the last slide, warranties. So two types of warranties, express warranty and implied. So an express warranty, that is what the company promises about their product. So that's created through advertising. So sticking with the Ledra-Plastic example, that's an express warranty that the product can withstand up to 600 pounds of pressure. As opposed to an implied warranty, that's the idea that I mentioned earlier, that the goods are of average quality for their intended use, so that an exercise bike, for example, could withstand a 150-pound person sitting on it. And probably, I think most of us would assume an exercise bike, if you just bought it from Dick's or something, that it would hold somebody up to 300 pounds. If I was going to guess a ballpark, that's about where I would guess that they could withstand. And if I was working with somebody who is over that weight, I would definitely check the manufacturer guidelines. But I think we would assume that at least it would perform at that level. So you could prove as the plaintiff violation of the implied warranty if the product doesn't do what the average consumer thinks it would do, I guess is a way of thinking about that. All right, so really long one. Let's see what the time is on this one. Hour and a half. But we usually cover tort over the course of 2 to 3 weeks in a normal semester, so 2.5 hours worth of video, not terrible. So at any rate, that concludes tort law, and then we'll get into risk management next time. So have a good day, and then do a good job on the discussion boards, and we'll see you for risk management.